Okay, I believe we are ready to start the panel discussion. So the panel discussion starting now will be held under the theme of the rule of law in the international community, perspectives from the global south. And we have distinguished panelists and moderator here, Professor Erika de Wet, University of Graz, Professor Dapo AKANDE, University of Oxford, and Professor Makane Moïse MBENGUE, University of Geneva. And this discussion will be moderated by Professor HAMAMOTO at Kyoto University. And I believe you already have the concept notes for the panel discussion, and I'll now give the floor to Professor HAMAMOTO. Thank you.
Thank you. So this is supposed to be a round table and the discussion table. So we are going to hear the three eminent panelists' opinions on the questions or points already presented in the concept notes. I suppose that you all have the concept paper. Therefore, I will not introduce the concept paper, then we will go directly into discussions. So you please feel free in joining debate discussions concerning the points raised by the distinguished panelists. So since this is the first time to have Professor de Wet, perhaps we should introduce, we welcome Professor de Wet from the University of Graz. She kindly accepted the invitation of the Japanese Society of International Law for its annual conference to be held next week in Fukuoka, and to take advantage of her presence, and we tried to invited her to this Tokyo International Seminar, and she kindly accepted that. She was, of course, you have her CV, short CV in the document. She was educated in South Africa and has taught in many places, Switzerland, the Netherlands, Germany, now in Austria. And among three panelists, we have one common element, which is, of course, Africa. And we are going to concentrate on the African experience of international law, and because the Asia has a lot to learn from the African experience. The first point raised in the concept paper, there are three questions. The first issue is well, the title was given, can we still believe in the rule of law? That's a big question. This is about the divisions among nations, among states, and under current considerations, what is needed further to consolidate the rule of law. The question is abstract, but the question itself is interesting, and we will kick off the discussions from first, Erika. You have the floor.
Thank you so much for that introduction. Dear colleagues, it is a great honor for me to be present today, and I would like to express, first of all, my gratitude to the Ministry of Foreign Affairs of Japan for having me here today. Now, I do believe in the rule of law, first of all, if we can agree that the basis is public international law and not the so-called rules-based international order, which is a term that has recently been introduced by some major powers, a term about which I am personally very cautious, because it can be at the potential detriment of public international law, since it seems to be able to mean anything that those who use it want it to be. So we need to be very consistent in terms of terminology to begin with and define what we mean. Now, as far as international law is concerned, we also need to remind ourselves that the law on the use of force, despite its immense importance and capacity for destruction if it is abused, as we see happening in so many parts of the world, it is not the only part of international law. It's only a fraction of international law, in fact, and many, or probably most other parts of international law function very well. Many of us here today have flown from somewhere else, from other countries. We lived international law by living international air law. Otherwise, we would not have been here if it had not been for the Chicago and the Montreal Conventions and so on. Everybody who has gone to a consulate in a foreign country for whatever reason, he's actually living and experiencing the Vienna Convention on the Law of Consular Relations. So that is something that we sometimes tend to forget. There is already some common ground that works quite well. And second, we need to reflect about the way we define the global north and global south. I personally do not find this division fruitful and helpful because it's very difficult to give it a meaningful definition if we take geography as a point of reference. Some of Africa's poorest countries are in the northern hemisphere, whereas some fast developing regional powers with booming high-tech industries and space capacity are in the southern hemisphere. And from the perspective of the consolidation of the rule of law, it might be more fruitful to take a sectoral approach within which countries from across the globe can work together on issues that particularly affect them. A good example is that of climate change, where countries that regard themselves as particularly affected from all geographic regions have, for example, already collaborated closely in the advisory opinion on the ITLOS, on sea level rise that was handed down by the ITLOS. Countries from all regions came together on that. So government officials could perhaps continue along this path of identifying like-minded states on particular issues, as this may generate support for very inclusive UN General Assembly resolutions in the medium or long term. And we as academics have to, and from all regions, have to remind our governments, both from the north, and the south, and the east, and the west, to act consistently, which I fear very few governments do. Nothing is more harmful to any legal order, whether it's a domestic, regional, or the global international order, than applying the rules only when they suit us. Arigato.
Yes, thank you, Shotaro, and good morning, everyone. When I saw this question about should we still believe in the rule of law, I had a little smile like now. Well, you know, quite often the international legal system is characterized as a voluntarist system. Whenever we talk about international law, we insist a lot on consent. We insist on free choice of means. For instance, if you think about peaceful settlement of disputes, the principle is free choice. So the voluntarist character of the international legal system is something that is inherent to the international legal system. But I think that when it comes to the rule of law and believing in the rule of law, this is one of that layer of the international legal system where I think choice is not present. Voluntarist character or nature of the international legal system should not be present. It is a fact of life. It is a need within the international community for states, but also other actors, non-state actors in particular, to believe in the rule of law. And of course, as someone coming from Africa and advising many African countries on international law, quite often this is what I tell governments in Africa is that, you know, we need to subscribe. We need to subscribe. There is a need for adherence to the rule of international law. And I tend to believe that for developing countries, global south countries, so for countries that are more vulnerable, like many African countries are, I think that actually believing in the rule of international law is a sine qua non. Is a sine qua non for for our preservation, is a sine qua non for our sovereignty, is a sine qua non for our very survival as young nations. But then, of course, you know, believing in the rule of law is not just a matter of faith. It should be also a matter of practice. You know, it's I like this sentence: "Practice what you preach," because it's one thing to preach the rule of law, the rule of international law, but then what is mostly important is to practice the rule of law on an everyday basis. And for me, practicing the rule of law or the rule of international law starts with a minima. And a minima is, you know, reiteration, reaffirmation of the core fundamental principles of the international legal system. We cannot allow to have some flexibility or abstraction on what are the irreducible core, what is the irreducible core of fundamental principles of the international legal system. So it's very important that in the everyday rhetorics, that states, but also as actors, really subscribe, constantly refer to those fundamental principles, in particular those that have been incorporated in Resolution 2625 of 1970. And it is something we try to do on an everyday basis at the level of the African continent. I speak under the control of the Honorable Legal Council of the African Union. But for instance, very recently, African countries were discussing the application of international law when it comes to cyberspace and new information technologies. And what did we do in that exercise? Mostly we try to come back to reiterate what we believe are the fundamental principles that are there. And I think that this is the starting point for any phase, any practice of the rule of international law. Then, of course, as African countries, I think that there are two challenges when it comes to this believing in the rule of international law. The first one is dissemination. Dissemination of what is the rule of international law. It's very important for the people in Africa, but also the governments, the institutions, to be aware of what are the applicable rules. You know, I go sometimes to countries in Africa where, you know, certain policies would be adopted, but just not out of bad faith, but out of ignorance of what is the applicable international law. And once you start engaging in more dissemination, you realize that there is, you know, good faith to go in the direction of implementing. So dissemination is very important, not only for African countries, in general, I would say in the global south. And then the second aspect, and I'll finish there, Shotaro, facilitation. You know, for states to believe, for actors to believe and to practice better the rule of international law, we need to facilitate compliance with the rule of international law. So believing in the rule of law should not be based on a confrontational agenda, on an agenda of accusing, of confronting. I think it should be more based on facilitative mechanism. How do we put in place facilitation strategies to actually support, assist global south countries from the global south, in general, African countries, to comply better with the rule of international law? Erika, you were mentioning right now climate change, for instance. When it comes to climate change, you know, many African countries are confronted with the reality that they have very, very limited, you know, budgetary resources, very limited human resources, very limited scientific, technological resources. So not complying with the so-called international law relating to climate change is not just for those countries a deliberate choice. It is just sometimes, you know, pure structural problems that those countries are facing that prevent them from truly showing their belief in the rule of law, in particular when it comes to certain global challenges. So facilitation is important. Thinking about strategies to facilitate in the global phase compliance with the rule of international law. Thank you.
Thank you very much. It's a pleasure to see all of you again. So in thinking about my response to this question of can we still believe in the rule of law, you know, one of the first questions that I thought about is what does the rule of law actually mean? And then the second question is to what extent does it apply in international law? So there are many meanings that have been given to the rule of law, particularly in our domestic legal systems. Some of those meanings have to do with just procedural compliance with the law. So it's more about, you know, talking about those who exercise public power having an obligation to act in accordance with the law. And I think that is also the case in international law. Some would give a more substantive meaning to the rule of law. In other words, not just an obligation to act in accordance with the law, but the suggestion that the law must have certain characteristics. And there it becomes a bit more controversial. You know, some people might put observance of human rights in there, and they put particular characteristics, and it becomes a bit more controversial there. But I think at a minimum, the rule of law has this meaning that those who exercise public power must act in accordance with the law. It means that those who are the subjects of the law are entitled to the protections of the law. So if that's what it means, the question then is, does this apply also in international law? And I think it does. I think we have a commitment in international law to states observing their obligations under international law in good faith. You look at the UN Charter, you look at Article 1 of the UN Charter, and I think, which deals with the purposes of the UN, I think there's even though it doesn't use the term the rule of law, but there's a commitment there to that idea of the rule of law, a commitment to the idea that disputes are to be settled in accordance with international law and justice. General Assembly Resolution 2625, which is mentioned in the concept note, which Professor Makane has mentioned, also reflects this idea of a commitment to the rule of law. But then the next thing I think that one has to think about in terms of the rule of law is, well, there must be law for there to be the rule of law. So to say that those who exercise power must act in accordance with the law suggests that law actually must exist on the particular thing that we are speaking about in relation to the rule of law. And so that's number one. And here I think actually there's good news in international law. Good news in the sense that we have much more of our international relations today which is covered by rules of international law than was the case before. Now, we shouldn't actually underestimate that that's important, because where there is no law, there is discretion, and there is the ability to act on the basis of interest, legitimately act on the basis of interest, legitimately act on the basis of power. So the first step actually is that there should in fact be rules. There should in fact be law that governs behavior. And I think today, with the various topics that you've been discussing throughout this week, in almost all areas of international affairs, we see the expansion of the law. And so, first of all, law exists. Okay, that's a good thing. That's step number one. And I think we should be proud of step number one. Step number two, then, of course, is law should be complied with, must be complied with. That is then the next point. Now, we know, of course, that in international law, compliance is variable, by which I mean you have some areas where there's a greater degree of compliance than others. And I think the point that Professor Devet made is one which is important to underline. We very often get focused by what we see in the newspapers. Violations and examples of violations stick in the mind much more than examples of compliance, because compliance is not the headlines in the newspapers. The headlines in the newspapers is violations. But that should not actually give us the impression that international law is not regularly complied with. This is the point she was making. So an American professor, Louis Henkin, he said this many years ago, I think in the 1980s, now a famous statement in international law. He said, most states comply with most rules of international law most of the time. When you read the newspapers, you might get the impression that that is not true. But that is, in fact, the case, that most states comply with most rules of international law most of the time. And you look at the examples that she gave. What I often do, actually, when I go occasionally into schools to talk about international law, is I ask people, the students, I say, look at the label on the jacket you're wearing or some item of clothing. Now, in the UK, this works very well because very often, almost invariably, the label will not say made in Britain. It will say made in Bangladesh, it will say made in Vietnam, made in China, or somewhere, you know. I say, the phone that you have, where was it made? And I ask them, how did it get here? How did that item get to you? Well, it got to you because of technology, but it got to you also because of rules of international law. Rules relating to trade law. 80% of our trade is still by sea, the law of the sea. Air transportation. I used to ask the question, how many of you have posted a letter from one country to another? You know, 20 years ago, everybody would put up their hands. Today, you know, when was the last time people posted a letter from one country to another? But the point is, we have rules that facilitate all of these things, and they are mostly actually complied with. So even at the level of compliance, I don't think that we should necessarily be misled. Now, of course, we have egregious cases of non-compliance, and we should not be satisfied that most rules of international law are complied with by most states most of the time, and we need to deal with those cases of non-compliance and think about how we can facilitate compliance. But even in some of the areas where we think about not, you know, I was talking yesterday about the use of force, we have egregious cases. The fact is actually, even in that area, it is not the case that there is habitual non-compliance by most states. There is egregious non-compliance in some cases, but it's not the case that there is habitual non-compliance by most states, even in the area of the law relating to the use of force. Okay, so this is all the sort of good news. Then the question is, how do we deal with those cases of non-compliance, and how do we think about the rule of law in those situations of non-compliance? What role does law play? My own view is that we often think about, well, the law should be complied with, it must be complied with, it has not been complied with, therefore the law has failed. So we throw up our hands and we say international law is useless because it has failed. But actually, in my view, even in those cases where we see non-compliance with the rules, the law still has a role to play. In fact, very often the law has several roles to play, even in those cases of non-compliance. And the fact that we have law and we have rules is still important. So first of all, actually, when we have law and when we have rules, it provides a standard, not only by which we can judge behavior, but it provides a standard that we can sort of gather around to be able to respond to that wrongful behavior. So in cases where we have law, it is easy, I'm not saying easy, note, I'm not saying it is easy, it is easier to be able to form coalitions to be able to respond to wrongful behavior in cases where you have rules and law, because you have common standards that you might be able to gather around. The cyber example, I think, is a really good one, because in that area where there is some disagreement as to what the rules are, you sometimes have incidents that occur where on the one hand, it will be argued by some, this is terrible, this is egregious. And then others will say, but this is standard, this is what we do. And that lack of agreement on whether there's a violation of the law means you can't even respond. You can't get parties to even agree as to whether what is done is not just harmful. You can't even get them to agree on whether it is wrongful. We all know it's harmful, but is it wrongful? When we have law, then we're able to at least come to a better agreement as to whether or not things are wrongful, and we have a better chance of being able to form coalitions to deal with those cases of non-compliance. The last thing I will say, I won't talk about it at length because we'll come back to it, is the importance of not only peaceful settlement of disputes, but also the importance of neutral application of the law through adjudication. I know we'll come back to this, but there again, all I want to say at this stage is that actually I think we're in a better position now than we were before. If you think about the number of tribunals that we have, the number of states that take part in these tribunals, it's far, far better than where we are. It's far from perfect, but we're actually in a better place now than we were, 20, 30 years ago. So it's a message of optimism.
Thank you. Thank you, and if I may add, even in cases of egregious breach of international law, the author states of those egregious breach always argue that they are complying with international law. And that makes the dialogue possible, at least, and we're on the same page. One of the points raised by the panel was the meaning of the rule of law. What do you mean by the rule of law? And in that context, I'd like to refer you to the second sentence of the concept paper in theme 1, that is, some complain and that the main legal framework of the international community today was shaped by Western countries before and after World War II. And if you haven't read the records of the Security Council debate in January 2023, where Dapo was present as an expert, and there was a debate in the Security Council on the rule of law. And there, the Chinese representative said something very interesting, which caught my mind. And I quote the phrase of Chinese representative, Chinese delegate: "To strengthen the rule of law at international level, we should ensure that all countries are engaged in creating international law. All countries, regardless of the size, power, and wealth, are equal members of the international community. International rulemaking is not the prerogative or privilege of a few countries, and is by no means a case of obeying the strongest." End quote. So what do you think of this kind of argument? The international law is a product of a powerful states, and particularly the Western states. Anyone?
Yes, thank you, Shotaro. I think that this is a good continuity with the first question on how should we believe. In order for countries from the global south to believe in the rule of international law, we need also to cure or to go beyond, what many perceive as, a double standard oriented international law. The rule of international law should be the same for everyone within the international community, and we cannot accept that there is one international law applicable for one group of countries and another international law applicable for another group of countries. So believing in the rule of international law is also a matter of preserving the unity of the international legal system. And at that level, developed states should take the lead. Taking the lead should not just be a matter of taking the lead with respect to geopolitical issues or with respect to economic issues. Developed countries should also take the lead in believing in the rule of international law and in enforcing or at least ensuring compliance with the rule of international law. But to come now to the second question on how do we engage better in general as global South countries or African countries. For me, there are mainly five aspects. The first one, solidarity. Solidarity, it's never very clear whether solidarity is a principle or just an abstract goal within the international community, but regardless of how you perceive solidarity, I think that solidarity is fundamental for ensuring more active participation, more engagement from the global South in the making, the interpretation, and the implementation of international law. In the African context, we often see that when we come together, it's easier. It's easier for us to have a voice. It's easier for us to have a strong position. It's easier also for us to make a contribution, to make a difference in many different international fora, because many African countries, of course, as you know, are not that powerful. So isolated actions do not really contribute to effective engagement with the international legal system or with rulemaking at the international level. So solidarity is very important. And solidarity can, of course, be based on more formal structures. So, for instance, using in Africa a regional organization like the African Union, or using regional economic communities. But solidarity can also very, very much benefit from informal mechanisms. We need to go beyond, the formalistic approach to what is engagement with rulemaking. Informal initiatives can have very, very efficient and positive effects. I'm thinking, for instance, about one forum in which I participate every year, which is called the Forum of Investment Negotiators from Developing Countries. So every year we meet. So one year it's in Africa, another year it's in Latin America, another year it's in Asia. So this year it will be in October in Manila, in the Philippines. So every year we meet. It's only a forum open to investment negotiators for developing countries. We meet and we exchange. We exchange because engagement with rulemaking requires solidarity in, learning, sharing of experiences. And Global South countries meeting every year, for instance, to discuss what are the challenges they're facing when it comes to the investment regime, when it comes to investment negotiations, etc., has proven to be very helpful to many Global South countries to better engage with the investment regime. So solidarity is fundamental. Second, capacity building. Capacity building or capacity strengthening or capacity reinforcing, call it as you prefer, but building capacity is fundamental. There cannot be effective engagement with the international legal system from African countries in particular if we do not invest more in capacity building. In many of the fields of international law, Dapo, you were talking about expansion of international law, but the expansion of international law has come up with the complexification or complexity of international law. International law has penetrated fields that are sometimes very technically complex. And so engagement with those fields like global health law, AI, cyberspace, etc., requires capacity building for the countries to be aware of what are the rules and how they could shape the rules when they engage. Number three, which I think is important for better engagement, is developing a culture of using the system. in my personal experience, in many countries, in particular African countries, there is sometimes reluctance. Even when the system gives rights to those countries to use it, there is reluctance to use the system. And engagement means also a culture of using the system. I guess you remember, Shotaro, about 20 years ago, when there was this cotton dispute at the WTO, where Brazil filed a case against the United States of America because of the subsidies that the US was giving to US cotton producers, and subsidies that destroyed the production of cotton in the developing world. The most affected countries by those subsidies were African countries, what we call the Cotton Four. Guess what? None of those African countries used the WTO dispute settlement system to bring a case against the US. Only Brazil used the system. These are the same countries that will tell you that the system doesn't allow them to engage. Before you can conclude that the system doesn't allow you to engage, you need to try to use the system. So I think engagement is also based on developing this culture of using the system. And then number 4, importance of expertal diplomacy. Expertal diplomacy, and this is connected to what I was saying earlier on about the complexity of certain issues. Certain issues are so complex that some governments in the global south in general, or in Africa in particular, do not have the technical expertise to engage. So it's very important that we push more and more in the global south for what we call today expertal diplomacy. So using our experts, using our national experts, or using our regional experts that are aware of the needs of global south countries, of African countries, to actually help those countries shaping their strategies, developing position on issues of international law. And then, last but not least, one aspect that I think is very important when it comes to engaging requires a sort of psychological posture, psychological shift when it comes to rulemaking. And that psychological shift is what I like to call the need to go from rule takers to rule makers. So Shotaro, you were provoking me on asking me whether I think that the international legal system has been mostly, shaped by a group of powerful countries. Surely at a certain point of the development of international law was very reflective of the visions of a certain group of powerful countries. But today, I think the international legal system allows for participation from everyone and allows everyone to really contribute to rulemaking. But for that, we need to operate that psychological shift, which is, let's stop as global south countries to be rule takers, and let's try to be more rule makers. Let's go for Africanization of certain fields of international law. Let's go for Latin Americanization. Let's go for Asianization, if we can call it like that, of certain fields of international law. We need to make our voice being heard and not just consider that international law is static in content and has to reflect what some of the textbooks say. It has to reflect. So I think we need that psychological shift. Thank you, Shotaro.
Thank you. We have already entered theme 2, which is quite reasonable because theme 1 and theme 2 are tightly related. Do you have any, Dapo, do you have, this? Okay, what on?
What is the order? Yeah. Okay. Thank you. I think we're now sort of into theme 2 already, as you said, so I'll just connect there because the examples that I prepared actually fits very well with what Makane has just said. Let me just also say that in terms of solidarity, I think the flip side is also responsibility. Each state, we have also within regions. If you take the region of Southern Africa where I grew up, You have vast capacity differences between South Africa and Lesotho, which is landlocked by South Africa, to name but one example. So it's, once again, it's not merely a north-south division. We have divisions, capacity also differences within our own contexts and regions. But the responsibility that you can take, you must take. Because I think that what also has to do with a mind shift and the reluctance to engage and to be proactive in the system, that is sometimes a reflection of a victim attitude, which I don't think is very, I understand where it comes from after what all developing regions have been through and a certain distrust and so on. But sometimes states can do more than they perhaps believe they can. And if they are more proactive, they will benefit from that. And sometimes one has to ask whether they deliberately want to escape some sort of responsibility as well. One example, during the COVID pandemic, my country of origin, South Africa, I'm now a proud Dutch national, but I'm kind of a hybrid, you know, I cross over from the north to the south, to the east, to the west. So I'm a bit of a mix, but for example, during the pandemic, South Africa, due to pure laxness of the government at the time, did not pay its deposit to the WHO, for which, as a result of which it could not qualify immediately for the vaccines that were available at the WHO for developing countries. Now, of course, there are a lot to say about how developed and industrialized countries could have done more. I agree with that, and that's a separate discussion. But if your own country's government is too lax to simply pay a deposit, which should have been paid, it's not the West, it's not somebody else. You know, you should start taking responsibility at home. So this copping out of personal responsibility, where you can actually take responsibility, is not helpful. And then also when it comes to using institutions, now, a lot of emphasis is placed on compulsory adherence to the, for example, jurisdiction of the ICJ and so on. I don't think that is necessarily the only way to go. One can, of course, make propaganda for that. But I think if one looks, for example, at how developing countries, in particularly from Africa and Latin America, have learned to use the ICJ and the ITLOS and other dispute settlement mechanisms to their advantage over the last 15 to 20 years, it is incredible. Yes, they were shaped and created by colonial powers. I can hardly think of an institution more colonial than the ICJ. Yet it has become, it's like this relic, you know, from the early 1920s. But it has gained so much credibility over the last 20, 30 years, especially in the developing world, which tells you that countries are learning the rules and how to engage and use these rules to their own advantage, and in the process also shape international law. And that point has already been raised. But the ICJ had to work hard to gain this credibility after the disastrous Southwest Africa cases in the 1960s. But Judge Yusuf, a former president, in an interview last year with the Max Planck Yearbook on United Nations Law, indicated that the court became more sensitive to the needs of other regions. So there has been a development over time. Okay, so however, I also think that developing countries, one area which developing countries now need to pay more attention to when they use these international bodies is not only to use counsel from elite institutions from France and the United Kingdom and the United States, which they voluntarily turn to, and sometimes the law firms with which they work also pressure them to do so, but they can and should also include more people from their own regions who are skilled and can do so, because that also enhances credibility and coming across as diverse and inclusive. Now, one positive example where this has recently happened is the case between South Africa and Israel, where both sides had highly skilled counsel, mainly from their domestic jurisdictions. Now, regardless with whom you agree on that case and with the case as such, That was one of the few cases where it wasn't just the usual suspects from a few, you know, all this clubbiness of all the same people being recycled. Because I do think that that also affects the credibility of these institutions. I have one comment, a more critical one, on the International Criminal Court when it comes to the whole issue of advancement, but I'm not sure this is the moment to express that, or perhaps later. Okay, we can come back to that, and then I'll stop here and pass the microphone to Dapo.
Thank you. So, you know, theme 2 is asking how should we engage in international rulemaking, and looking at essentially the question of how do we do that on a basis which is truly global and which involves countries from all parts of the world taking an active part in international rulemaking. And it's a really good question because, as I said earlier, you know, the rule of law in the first place requires that there be law, and then the second place, compliance, but compliance is more likely in circumstances where you've been involved in creating the law and where the law actually reflects your interests. So how do we achieve law that actually reflects truly global interests? Just sort of taking a step back and looking at it sort of more theoretically. Well, I mean, what we all know, right? So we say international rulemaking. Well, what are the sources of international law that we're actually talking about? How do we make law? So it's treaties, it's customary international law in the main. And so how do we encourage countries to be engaged in that process? Now, if we take treaty making, we might say that in one sense, we have a bit of a sort of crisis of multilateral treaty making, in the sense that we're in a stage now where we don't see many new treaties that are being concluded in a range of areas. The development of the law in many areas seems a bit stalled. And I think there are different aspects actually to trying to encourage that. Some of them are procedural. So what sort of procedural changes can we make to energize treaty making, and what sort of changes can we make to ensure that this happens on a global level? And then, of course, there's political will, and that's always going to be an issue. Political will just means states have to think that this somehow reflects their interests. And how do we get states to think that these issues reflect their interests? But I want to concentrate maybe more on the practical issues, because there the solutions are a bit easier. So one of the big questions that I think, for example, is being faced now at the UN, those of you who are involved in the General Assembly, in the 6th Committee, is the whole question of, do we always proceed by consensus, for example? Because sometimes, I mean, consensus is a great thing when you can get it, but when you can't get it, it means that you don't do anything. And so I'm a member of the International Law Commission. One of the big problems that has arisen recently with the work of the Commission is it gets to the UN 6th Committee, and nothing happens at the 6th Committee because there is no consensus to take it forward. And so at the moment there are discussions to do with negotiating a treaty on crimes against humanity, and they're arising out of the International Law Commission's work. And there somehow they were able to make progress even though it wasn't on the basis of consensus. And that's something that we really need to think about. Because, you know, we might, and my own view is that at least at that procedural level, to be able to proceed to treaty negotiation, to require consensus even to be able to negotiate, seems to me like a very, very tall order. Just to be able to negotiate, well, you negotiate, and then of course states have opportunities to decide on how to shape the rules, whether they agree, whether they will agree to the adoption, whether they will then ultimately choose to ratify and become parties. But if you need consensus even to be able to negotiate, then you're stuck. You know, you have big difficulties there. Other practical issues around even the venue, the fora, for being able to engage in treaty making. I have to say this was something that I hadn't myself really paid attention to until the last couple of years. the whole question of, do you do it through some kind of diplomatic conference or do you do it through New York? It's only in the last couple of years, talking to some diplomats from developing countries, that it occurred to me that actually this has huge practical significance. Because at least in New York, all states are there. They all have representation. Many of them have lawyers. But if you're going to do it through a diplomatic conference that's going to meet in some other country somewhere where they don't have representation, they're going to have to pay a lot of money to get their lawyers there, the prospects for global participation actually drops. So whether or not you will be able to get enough countries to be able to go and participate in those discussions is more difficult, depending on actually just the venue that you choose and the forum that you choose for treaty making and treaty negotiation. So those are just practical things actually that one needs to think about. Customary international law. How do we get the voice of countries from across the globe involved in customary international law? There's actually a significant, it's almost a theoretical issue, but it has huge practical consequences. So we say custom is about state practice and opinio juris, but the question arises, what is state practice? Is state practice just what states do, or does it include what states say? Now, the reason why that is actually important for getting global participation in lawmaking is that if you take the view that state practice is just what you do, many times states don't have the capacity to do. If you say it's just about taking concrete action, sometimes it's only a few states that can take concrete action. But you know what? Every state has the capacity to say. Every state has the capacity to express a view. And so having a position that actually the formation of custom includes, in terms of state practice, what states say is actually really significant, because it means that all states can take positions on rules of customary international law. Now, of course, they then have to take those positions. So yes, you open the door. This is like what Makane was saying. There's a capacity to engage in customary lawmaking, but then you have to walk through that door and you actually have to do it. And the question is, how do you do it? I'm just going to repeat his point. It's easier very often to do it on the basis of solidarity, on the basis of doing it on a regional basis. Now, I know that this happens, for example, at the UN. You have regional statements that are made so that it's not every country having to kind of immerse itself on every issue. And then yesterday, in my lecture, we were talking about the AU position on application of international law in cyberspace. That's a great example of countries in Africa coming together to be able to express positions on rules of international law, so that when I come to Tokyo, I'm not just quoting what did France say, what did the Netherlands say, what did Japan say. I can also say, what did the AU say when we are thinking about what rules of customary international law is. Put that on the table and it helps to shape what the law actually is. But of course, to do that, capacity issues are significant. Capacity building is important. What we're doing here is important. So all credit to the Ministry of Foreign Affairs of Japan for organizing this, because it's really important to have the capacity to feel confident, actually, to be able to take those positions. And then the last thing that I will say in terms of being able to, what Makane has described as using the system, so take the position, it's actually not, there's capacity, but what I have also come to discover in the world of international law is that individuals matter, and individuals matter hugely. I don't think that, or let me put it more positively, I think that all of you should not underestimate actually the capacity of individuals, you, to make a difference. You know, I have seen areas of international law where just having particular individuals, you might think, well, maybe my state isn't so influential on this or that, but actually there are many areas of international law where having the right individuals there at a time has made a big difference. You think in the past about, so in the 1970s, for example, in the immediate kind of decolonization period where you had very active participation by many developing countries, and I'm thinking particularly of African countries, but not just the African ones that were newly decolonized, their capacity was not higher than the capacity that exists now. What existed, though, is you had a number of really motivated individuals that were very influential in some of these negotiations. To name a few names, Judge Koroma, who worked as a judge at the International Court of Justice. I think Makane worked for him when he was there from Sierra Leone. When he was foreign minister of Sierra Leone in the early 70s, and when he was ambassador of Sierra Leone at the UN, he was extremely active in some of the positions that we're taking at that time. Judge Elias from Nigeria, before he became Judge Elias, you had certain individuals who just played a key role in certain key moments at that time. And I'm using examples from the past, but it is still true today that you still have some individuals who take a key role and are able to move things forward, even though you might look at the state and you might say, well, this state is not necessarily the most influential, but the individual sort of matters.
Thank you. Well, concerning the limits of consensus in rulemaking, I remember in answer to a United Nations Commission in International Trade Law, where I'm a member of Japanese delegate, we took 2 years, perhaps more than 2 years, to just define the scope of discussion concerning the ISDS reform. Actually, yes, that was a tough moment, but now. Anyway, we are going now getting to the theme 3, which is a somewhat different subject. So I think it's the right moment to open the floor. If you have any questions or comments, or opinions concerning the rulemaking engagement or questions.
Thank you. I will just limit myself to some of the answers, and I guess we will somehow get to all of them through with all the answers. As far as enforcement, what I picked up is a very legitimate concern with lack of reform of the Security Council and how to enforce certain decisions of the ICJ. Now, once again, most decisions are adhered to voluntarily because most cases go there voluntarily and accept the jurisdiction, but I suspect you also refer to the Gaza decision amongst others, and those very controversial decisions pertaining to the use of force and the issue of reform. Now, there are different things that we need to keep apart. On the one hand, yes, the issue of reform needs to be kept on the table. It needs to be, we need to remind the international community of that on a regular basis. In doing so, also within regions, we have to do some introspection, because part of the problem also is that, for example, within African states, we cannot agree what a new Security Council should look like. That doesn't help our cause. You have similar problems in Asia. If we cannot at least come up with some suggestion of what we as a region or a sub-region want in there, you know, we're making our own lives very difficult in trying to reform the system. But that, of course, is no excuse for not enforcing those decisions that have been handed down by the ICJ. And you're absolutely right, there's a problem with the Security Council acting. But do not underestimate or forget that thanks to the Articles on State Responsibility and the decentralized nature of international law, there is such a thing as decentralized enforcement. As we speak, thanks to the Gaza decisions, there are domestic court cases in the Netherlands, in Germany, in the United Kingdom, which are it has activated a huge political reaction and legal response about, for example, the exportation of arms and so on. Countries are terrified now also in what has to be, in the EU in particular, about becoming criminally responsible before the International Criminal Court for complicity in crimes if they keep on exporting certain weapons. Then there's also the Arms Treaty, to which many of them are a party, which is a different, it's not related to the International Criminal Court, but classic state responsibility, but which there are huge issues, and so on. There are several cases, and also relevant for the European Court of Human Rights, and all sorts of things. So those avenues are not entirely useless, and I agree that they may not in the short run result in the ceasefire that we want to see. But it can, over time, and the law works slowly, judicial mechanisms used slowly, at least ignite responsibility for some individuals. So I would pursue these things together and not see them either or, but try and pursue all of them at the same time. I'll just make one other comment, and to some of the things we can get back to, and that is about how to engage for Asian countries where you don't have regional or sub-regional systems. Several of you, like also Japan, are members of the United Nations and the human rights treaties of the United Nations, and I think for the time being on the human rights level, those bodies, those expert bodies, which also have all sorts of problems, but at least that is an avenue which you can use and where people should be educated in using them. And as Dapo had said, it is so important to have the right people on those bodies. Individuals from regions can really make a difference if you have the right people appointed to the right bodies at the right time. I think I'll stop there because our colleagues will continue.
Can I just pick up on the enforcement point that Erika has made? You know, sometimes I often think we need to be careful to not expect from international law more than we expect even from our own domestic legal systems. So very often you will see in the newspapers, they will say there's a decision of the International Court of Justice, but the court cannot enforce its decisions. And I think, but which court in the world can? I don't know of any court in the world that enforces its decisions. Others do, but not the court itself. Then secondly, we have in our minds very often this conception of domestic law as it applies in domestic private law. So you have the law and as it applies to individuals. And again, I may be wrong because I obviously don't know what the domestic law of every country is. But in which country is there a body external to the government that enforces court decisions against the government? At least in the systems that I'm familiar with, there is no enforcement mechanism against the government. So our most important areas of law, public law, law that binds the government, at least in the legal systems that I know of, there's no way of enforcing it. So when the court says to the government, we had a case in the UK a few years ago that the government had unlawfully ended the parliamentary session. And then the court said to the government, you must do this. I know of no external force outside of the government that forces the government to comply. When the US Supreme Court says to the government of the US, you have unlawfully detained somebody, the military is unlawfully detaining somebody, I know of nobody outside of the government that enforces that on the government, at least in the systems that I'm aware of. And these are the most important areas of law, our constitutional law, our public law, but we expect the government to comply. And we expect that if the government doesn't comply, it pays, we hope, some kind of price for not complying. In the systems that I'm aware of, our domestic law, the most important areas of domestic law actually are not dependent, to my knowledge, on enforcement when it's the state. But then when we get to international law, somehow we think that it should be different. We ask questions about who is enforcing it against the state, who is doing that. So we have to be careful, in my mind, to not expect from domestic law something that is more than we expect in our own domestic legal systems. And that's why I think the point that Erika made earlier about it's not all about enforcement is actually hugely important. And my point is, even in our domestic law, it's not all about enforcement. What we do in domestic law is we try to build up some expectation of compliance, and that in relation to the government I'm talking about, I'm just talking about the government, and that we hope that the government will pay some kind of price if it doesn't comply. And that's what we also try to do in international law. So of course we want compliance, but compliance is not equal to enforcement. That's the point that I'm trying to make. And I think that sometimes we depress ourselves by going for standards which are it's just not going to happen. It doesn't happen in our domestic law. It won't happen in international law. And so we need to sometimes set our sights actually a bit more in a way which is a little bit more realistic. That's, yeah.
Just to jump back on what you just said, Dapo. You know, in Geneva, I'm in charge of teaching the compulsory course on public international law to all the law students at the university. And in Geneva, the public international law course, the students, they have it when they do second year of law. Meaning that during the first year, they hear about constitutional law, civil law, family law, about, you know, domestic legal systems that are quite sophisticated. And suddenly I have the challenge to tell them about international law. And one thing I tell them from day one is, you know, please accept that we are talking about a system that has inherent limits because it is based on state sovereignty. And so please don't come to class and compare the domestic legal systems, even if there are some basis of comparison, as you did now, Dapo, but please don't compare domestic legal system with the international legal system, otherwise you'll never be happy. That's what I tell them. And I tell them, if you accept from day one that we are talking about a system that is imperfect, archaic, and that needs to improve and evolve, then you'll make your life easy. And usually, that's how I bring peace in my class, avoiding every week people asking me why there is this violation or this other violation of international law. All that to say that, yes, I think that what the honorable colleagues here have raised, yes, we need to admit that there are weaknesses, there are limitations. We need to admit that sometimes there's a double standard, you know, in how international law is invoked and implemented. We need to admit all that, because if we don't admit that, we can never achieve the dream of, you know, improving the international legal system. We can never achieve the dream of making it better. So I think we need to admit those weaknesses. But once you admit the weaknesses, it doesn't mean that the rule of law is not there. The rule of law is there. So the question is, how do we use the rule of law to improve the international legal system? How do we, as a community, agree on what I call are the irreducible core principles of the international legal system to then improve the system? If in the community everyone agree on the fact that, you know, acquisition of territory by force is not possible, it's one step that allows, you know, to strengthen the international legal system. So that's why I like very much the first question. Should we believe in the rule of international law? The effectiveness of international law starts with believing in the rule of international law. So if we are discussing whether we believe or not, then there's no way we can improve the international legal system. For me, that's what I wanted to say in addition to what Dapo said. Now, there were two points, one on what is the missing point and one on Asia. I like very much the question on Asia. How can Asia be more active? But Asia is super active. Asia is maybe even hyper active. Maybe you do not realize because you, as an international lawyer from Asia, you are more acquainted with what is happening. But me, I can tell you as an international lawyer from Africa, and I speak under the control of the distinguished experts from ALCO, if I pronounce it well, Mr. Kiran, no, it's ALCO. I speak under the control. Every single day, you know, as an African international lawyer, I take inspiration from what is being done in Asia. Every single day. ASEAN. ASEAN is one of the most advanced, how do you call that, economic integration organization. We've been taking a lot of inspiration from ASEAN. I'm still doing a lot of international water law, for instance. The example of cooperation over the Mekong, that it's one of the most, you know, advanced model of water cooperation in the world. When Japan pushes for rule of law among nations, that is a very important doctrine that we are using in our, you know, interaction with other governments in the world. So there's a lot of things that are being said, done, developed in Asia that are a source of inspiration. And this is, I think, something that is very important. You know, engagement in rulemaking for Global South, and I understand that the concept of Global South is not always the best formula, but engagement in rulemaking from the Global South has to start also with us acknowledging our contribution, with us acknowledging that, you know, we can bring added value on the table. Quite often, when you speak with international lawyers from the developing world, there is this tendency sometimes of underestimating what we are doing. When actually we've been doing, and it's not only now. Dapo was giving examples of great names like Judge Elias. So, ICSID Convention, for instance, the Convention on International Center for the Settlement of Investment Disputes. Go and read the travaux préparatoires. You will see that most of the lawyers that contributed to the making of the ICSID system come from the so-called Global South. So we need also to acknowledge our contribution. We need to empower ourselves. If we do not empower ourselves, no one will empower us. And admit that, yes, we can always do more, but there's a lot that our countries are bringing on the table. Then on the missing point, I think that now if we were doing an interview in the room on what is the missing point, there would be more than 100, you know, versions of what can be the missing point. But for me, what I think is one missing point today is, you know, building more bridges, building more communicational bridges. And I think that what we are doing here today is a great example of, you know, a good practice of how we can build communicational bridges, you know, between countries of the world, not only developing countries, but developed and developing countries. This is what we are doing here. We all come from different countries, different backgrounds, different economies, and we are here to try to build communicational bridges on what we believe is the rule of international law and how we can better shape, better implement the rule of international law. So these are the type of initiatives that have to be, you know, more often put in place, I think, at the international level. Thank you.
We have 8 minutes to go, and there remains one huge question, which is how to promote the universality of international judicial organization. This is a huge question for Asia, particularly because, you know, in Asia states, there are only few Asian states who participate in the International Criminal Court, for example, and most of them do not accept the compulsory jurisdiction of the International Court of Justice. They do not appear before the ICJ. When it comes to investment arbitration, for example, last year there were approximately 60 cases in ICSID. There has been no Asian case. So what do you think of the theme 3, how to achieve the universality, international and judicial organization? Dapo, you have any comments or ideas? And I repeat, we have 7 minutes to go.
Yeah. So, look, of course, in terms of promoting acceptance of international judicial bodies, I think the first thing that I will say, and again, this is me just trying to be the optimist, is that actually the place where we are now is very different from where we were before. So yes, we can look at the number of states that have accepted the compulsory jurisdiction of the ICJ, and we say, well, it's about 75, so it's not very high. But actually, the number of states that are using the ICJ is very high. So the number of cases that are before the court at the moment, it's a large number in terms of contentious cases. And then states are using the ICJ now in different ways. So for example, through advisory opinions, I find it mind-blowing, really, to think that today, more than half of the states in the world today are involved in one proceeding or the other at the ICJ. I think if you told students that even 3 years ago, they would have said, what are you smoking? I think would have been the question. More than half the states in the world are involved in one proceeding or another at the ICJ. So that's a good place. But of course, we shouldn't be complacent. Well, all I'm trying to say is that there are different ways in which the ICJ can be used. We need to continue to promote compulsory adjudication, acceptance of the compulsory jurisdiction of the ICJ. But I think it's also a good idea to continue to look at the other ways in which ICJ jurisdiction can be accepted. One of the things that I actually think is most disappointing, if you look at the treaties that provide a compromissory clause and which make reference to the ICJ, the numbers have dropped hugely, actually in the last 40, 50 years. States very rarely today now include a compromissory clause in a treaty providing for reference to the ICJ that is not by consent of the parties. And I think we need to look at that too.
Thank you. I would like to latch onto the issue of capacity building, which was already raised before. But I think it's an old-fashioned principle, but it's a very important one. And I think especially these types of exchanges and capacity building in an international multicultural setting is incredibly important because you do get exposure to other interpretations and other understandings of specific principles of international law, for example, state responsibility or duty of care, which we may all agree on in principle, but when you start applying, you don't necessarily agree because people have different perceptions due to their socialization, the needs of their region. So I think that is very important. And what I think is incredibly important is that we do not neglect in our education systems and in our exchanges and capacity building, general principles, the general basics of international law. There's an immense, in my view, overemphasis these days on specialization. People specialize at a very young age in either trade or environment or human rights or something else without understanding that all of this has to be linked back to state responsibility, enforcement, sources of international law, interpretation of treaties. They don't know how to do it. They don't understand the cross-links between these issues. One project which I found did it very well was the ILC's project on the enforcement, the protection of the environment in armed conflicts, a project which to especially also Africa is incredibly important due to the high number of conflicts. But there, the rapporteur in the end anchored all these different branches, IHL, environment, human rights, very well into classic international law principles. So the lack of capacity on the African continent, where I taught for many years, is very, very big, especially when it comes to the most basic elements of international law. And in South Africa, for example, you would have pockets of excellent human rights lawyers, but they don't understand that this is actually a branch of international law. And then you have some good trade lawyers, and you have the same problem there, and nobody ever speaks to one another. And in other parts of the African continent, it's even much worse. And there's one textbook in Africa that I'm aware of, in the English speaking textbook, that was written on the continent itself, and that still is John Dugard's the South African perspective on international law. All the other textbooks still come from France and the United Kingdom, and there people familiar with the continent, whether we're in the diaspora or somewhere else, really have to ask ourselves, isn't there more we can do? Because also on that level, it can really enhance universality. And I don't know what the situation in Asia is, where you have a huge region with many, many people and huge diversity. But also in terms of just giving your own flavor to your own textbooks in languages which we can all also access, because if we can then, for our research, access this. I'm currently working on defense alliances in the Indo-Pacific for another conference in the US later this year, and I so much struggle to get legal texts in a language which I can read on those incredibly important treaties. And these are all just basic stuff, education, making it accessible, but in a way that is much more inclusive than we are used to doing. So I think, and using that in ministries and in universities would already be a great step forward. Thank you.
Thank you very much. Shotaro, I think that when we talk about universality of international judicial organizations, I think we need to go beyond the procedural dimension of it. Because quite often, when we international lawyers think about universality, we think in terms of access to those courts, we think in terms of acceptance of the jurisdiction or compulsory jurisdiction of those courts. And of course, the procedural dimension is important. But I want also to invite all the distinguished colleagues and friends here to reflect on the sociological dimension of the universalization or universality of those courts. Sociological dimension. First, universality in the promotion of international courts and tribunals. It is not only today for states to promote the importance of having recourse to international courts and tribunals. All of us, the peoples of the world, the peoples of the United Nations, we have a responsibility to actually promote the use of international courts and tribunals. I'm just thinking about one example in which I was personally involved. I guess many of you here have heard about COSIS, the Commission of Small Island States on International Law and Climate Change, which was behind the request for an advisory opinion before the International Tribunal for the Law of the Sea on Climate Change. Well, guess what, if you don't know the story behind COSIS? COSIS, it's 3 professors of international law that thought about drafting a treaty and then convincing some small island states to sign it and ratify it and create the organization. My humble person, Professor Paya Makavan, and Professor Jean-Marc Touvenin, Secretary General of the Hague Academy of International Law. We are the ones behind COSIS. Many governments think it was a government initiative. No. So universality, promotion of universality, can come from different actors in the system and should come from different actors when, in particular, when the issues are global issues. Issues that are, how do you call that? Common concern of humankind. The common concern of humankind is not only the concern of states, it's the concerns of the entire humankind, and everyone should contribute to the promotion of universality. There's another facet of the sociological dimension of universality, which is engagement. Engagement. What makes international courts and tribunals universal is not just that all states are accepting their jurisdiction. It's who is engaging with these courts. You were mentioning, you were referring to it earlier on, Erika. When I was looking a few months ago at the delegations of the states that were involved in the Palestine advisory proceedings, those who advocate for states, who presented oral arguments, when I saw that my dear brother Dapo was in the delegation of Japan. That was great. For me, this is universality. This is universality. My first appointment as arbitrator in an investment case was done by the Philippines, a country with which I've never had any link at all. I've never been there before recently, and this is the Philippines that appointed me for the first time as an arbitrator in an investment case. For me, this is universality. Universality is also about thinking about future generations. How do we make sure that future generations of people from the global south have the chance to be acquainted with these international courts and tribunals? You know, I was a clerk at the ICJ 20 years ago. I was a clerk at the ICJ. I worked for Judge Koroma 20 years ago. I was lucky as an African to be a clerk at the ICJ. Why? Because I was doing a PhD at the University of Geneva. But then let's think about all those young lawyers, excellent young lawyers from Africa, from Latin America, from Asia, who should be given a chance. We are not going to Oxford or Cambridge or Geneva, but still we should be given a chance to be acquainted, to learn about the functioning of those courts. Because these are the people of tomorrow. These are the leaders of tomorrow. These are the generation which tomorrow will feel comfortable. So we need also to work on that. And you know, support from developed states is very important, because if you come from Eritrea or from Senegal, even if you are selected to be a clerk at the court, you don't have the means to stay 10 months in The Hague. So promoting universality is also about investing in future generations and to develop a culture of international adjudication. I will just finish, Shotaro, if you allow me, on Martin Luther King's dream. I have a dream. The dream of Martin Luther King was that universality is that all people of the world should feel as one. They should feel as one. And when it comes to international law, I think that this is the dream. We should all feel as one when we speak the language of international law. When we deal with international law, we should feel as one. And so again, having this type of seminar, like the Tokyo International Law Seminar, at least from me, from my perspective, allows me to feel as one. And I would like again to thank very much the government of Japan, the Ministry of Foreign Affairs of Japan, for giving us this opportunity. Thank you.
Thank you, Makane, for wonderful concluding remarks. And the time doesn't allow me to open the floor once again, but please join me in giving a warm hands to the wonderful panelists for the excellent discussion. Thank you.
Well, thank you very much for the truly insightful discussion, and I also thank the participants for your active discussion participation. Now, I would like to take some time to invite Mr. Tomohiro Mikanagi, former Director General of International Legal Affairs, Bureau of Foreign Affairs.
Sorry to suddenly take floor. I'm the former legal advisor of Japan, and I could not help expressing my deep thanks to all the panel and moderators and also participants at the end of this seminar. I was legal advisor until last week, and I am responsible for creating this seminar last year, and also responsible for asking you to participate in this panel. Last year, we didn't have a discussion panel like this, but I thought it would be a right time to have some discussion among the lecturers, as we have excellent lecturers from different countries, and you ask very good questions during the lectures, but sometimes I think you are interested in how lecturers would discuss among themselves on interesting issues, and today I think you could enjoy the views sometimes differ from each other, but sometimes there was consensus. So I think this should continue in the last year as well. I liked the questions you asked. The world is divided and confrontational, but I hope you can learn from the optimism expressed by Professor Dapo, AKANDE and Makane and everybody here. I think we need to share that optimism towards the rule of law. Otherwise, we will lose the goal and just accept what the world is now. So I hope you can finish this seminar with a kind of belief in the optimism. Thank you very much.
Thank you very much, Mr. Mikanagi. And now this concludes all the sessions of the Tokyo International Law Seminar. And we will be holding the completion ceremony at around 1 p.m. So please come back to your seat before that time. Thank you.